My name is Ben Rhodes, and I am the Senior Vice President of Association Management located in Charlotte, North Carolina. Thank you all for joining us. Today's topic will be communicating in a crisis, and maybe keeping you out of trouble with some of your communication and not creating a crisis. So as a reminder, all this information will be posted on the CAMS MGT website under the board members section. So if you have any board members that are asking to view this at a later date, that information is there, and then other webinars that we have hosted are also located on the board section of the CAMS MGT website. Morgan, if you're out there.
Hey.
Excellent. So
start my video.
Show your camera. Quickly introduce Morgan. Morgan is an attorney with McCabe, Trotter, and Beverly. Her practice includes day-to-day counseling regarding the management and operations of associations, including general advice, document review, and drafting. She has been representing community associations for over 7 years in both North and South Carolina. So, Morgan, I will turn it over to you. Before I do that, reminder, we are going to be moderating this session, and you can ask questions throughout this session. There's a little Q&A icon located at the bottom of your screen, or I should say in most screens. So if you do have questions, please feel free to ask. I will be coming back on the screen to help answer or ask some of those questions. And then I'll probably disappear again. So anyway, Morgan, the floor is yours.
Hey everyone, thank you for joining us on, it's Friday Eve. To talk about communicating in a crisis. If you have any questions, please pop in and ask them throughout this presentation. I'm going to try to keep it formal or informal conversation with all of you. So if you have questions, please use the Q&A button to do that. So what inspired this webinar was the COVID-19 crisis that we're all experiencing right now. COVID-19 is going to be the primary example that I'm going to use with regards to communication in a crisis. But there are other crises that come up in the community association realm. One that often comes up in South Carolina and North Carolina, for that matter, are hurricanes, and we're approaching that season. So this is good information to take with you and carry with you into other, other crisis examples. You can likely consider it a crisis. I want to go ahead and define what I think is a crisis. If there is a potential for the association to be exposed to some sort of liability or property damage, and there is less than a week's time to act. Right? If we have a week or more to make a decision, is it a crisis? Probably not. So I want to go ahead and start with a poll to get some interaction to see how many of you are actually dealing with COVID-19 related communications right now. So let's see here. All right, here we go. All right, I think everybody has sort of answered. All right, so I don't know, can they see the results? Let me just read them out. Have you sent out COVID-19 communications? 70% of you said yes, 30% said no. Have you had any COVID-19 cases? 30% of you said yes, and 70% of you said no. Wow, interesting. All right. So a lot of you have sent out COVID-19 communications. Maybe not all of them were crisis related. I bet some of them were related to your community elements, your community facilities, and things like that. They may not have been an urgent need. But what inspired this particular webinar wasn't a crisis communication related to a COVID-19 confirmation for an attendant that was at a pool. What is the association to do when they get notice that their pool attendant who's responsible for cleaning the facilities is positive for COVID-19. Well, I think in this case, the community did the right thing. They called legal counsel first, and I helped them draft something very quickly that went out the same day. So let's talk a little bit about what needs to happen, the how, the means, and the whom. When there is truly a crisis, we're talking about an urgent situation and we have less than a week to respond. However, there's an emergency to it, there's an urgency to it, but we need to be careful to slow down. Take a deep breath and be sure to not make any major mistakes. I know that's easier said than done. So one of the first things you need to ask yourself is, does this communication need to be prepared with legal counsel review? It depends on how much time you have, I think, and it depends on how much you know about the situation and whether or not that actually involves a pending legal matter. In the case of COVID-19 crisis, this particular community association called me, and that's wonderful. Do I think that all associations need to call legal counsel before they make a COVID-19 communication? Probably not. I'm hoping to give you enough information here today to not have to call your legal counsel so that you can make a judgment call about what needs to be in that communication, how it needs to go out, and when it needs to go out. Many boards are going to be considering what they need to put into an urgent crisis communication via email, right? If an emergency comes up, you may pick up the phone and call a few people on the board, but most likely to get everyone in the loop, it's easiest just to send out an email. Hey, guys, we need to talk about this. This is happening. And include all of your board members in an email. What does that mean when you are conducting, association business via email? Do you need unanimous approval of all the board members on the communication you're going to send out? I think that's a very important question you need to ask yourself at the beginning. It depends on the language in your documents, though. A lot of your bylaws are going to say specifically that informal decisions by the board need to be by all of the board members, or they're going to say some percentage, a majority of the board members need to respond. Some of you may be really lucky and your bylaws may actually say that electronic decisions or decisions made via email or via telephone conference do not require unanimous approval. Also, a lot of your bylaws are going to say that you can hold board meetings via telephone conference. So if it is at all possible and you have a crisis and you need to get a board consensus on what that crisis communication should say and when it should go out or how it should go out, and you need to have a board vote, the best thing to do is probably to get everyone on the phone and actually hold a board meeting over the telephone. If it's not possible, like I said, email is a possibility, but you need to review your documents now so that you're prepared when this issue comes up and you know if you need unanimous approval. Another question, do you need a formal motion approved by the board prior to this communication that's in a crisis? I think that depends. If you're going to do it via email, calling for a motion and requesting people to second that motion and then submit their votes is probably unnecessary. It's a little superfluous because you've already got everybody on the email. You've talked about what the email is. You should just probably call for a vote. The motion itself, the process of calling for a motion in a meeting is to make sure everybody knows what the vote is about. Well, in an email correspondence, everybody can look back in the chain and see what they're voting on because it's actually written before them. Should you document the discussion and decision of the board in the next board meeting minutes following the communication? Probably yes. Like I said, this is happening in a tight window. You're going to have these discussions in a matter of hours, most likely 24 hours, 48 hours. This crisis communication discussion is going to be held by the board members and a decision is going to be made. Are you going to have time to actually have a board meeting in between the decision and the communication going out? Probably not. But the next board meeting that comes up in the next week, in the next 2 weeks, a note should probably be dropped in the board meeting minutes that, hey, we had either a telephone board meeting on this date prior to this communication, and these board members participated, and it was decided that this communication was approved, or this communication was approved via email by the following board members, and it went out on such and such date. Always try to document your major decisions, including crisis communication, in your board minutes somewhere. And not everything needs to be in the board minutes, right? If there's confidential information that is discussed that goes hand in hand with the crisis communication, then we're not putting that in our board minutes. You can even make a note in the minutes that this was an executive session of the board at which the following people participated and the communication was approved. That's fine as well. Particularly in the situation of COVID-19, most likely the report that's going to be made to the board or the manager is going to say, has COVID-19, and he was at the pool on Friday, and everybody there needs to be contacted immediately. And you get this message, you say, okay, how much of this information needs to be shared with members? Do we need to tell them it was Joe? Definitely not. And I'm going to get to that later in the presentation, but do we want to put that in the meeting minutes that so-and-so called us and said Joe Smith has COVID-19? Same rule applies. You don't put it in the communication, you don't put it in the minutes. All right. So once you decide to make a communication, the next question is who should make that communication? And that's pretty fact specific. Is it appropriate to come from the manager? Is it appropriate to come from the board of the collective group? Or how about just one specific person on the board? Most of you probably already know this, or maybe it's news, but by default, the president of the board is usually the spokesperson of the board. And so if a formal communication is made, or any communication for that matter, is made by the president, and the people listening or hearing or receiving that communication knows this is the president, by law, that is an official communication of the board. The same thing can apply to other officers, but they put more weight in what is said by the president. So let me pause here and see if anybody has any questions so far. We've talked about what a crisis is. We've talked about how to decide on what communication is made, when you should decide, whether you have a meeting or not, and then who should make the communication. Do we have questions? I think you're muted, Ben.
Sorry about that. Yeah, we do. One question: why must a board vote on an email? We have a communications manager responsible for sending it out. The board never votes on other emails.
Well, if it's truly a crisis, so let's say you've got, I think these are unusual circumstances. We're not talking about your communications, normal communication matters. These are urgent matters that have never come up before that your communications person probably doesn't know how to deal with. It's something that, so-and-so called the board president and said someone has COVID-19, what do we do? Does it even warrant a communication? You need to ask those questions before it goes out. I don't think there is a default answer for this. So in a crisis communication situation, the kind that is envisioned by this presentation, this is not normal. This is not going to go through the normal chain of events.
Okay. Next question. What if your community documents don't have any reference to email voting? Is there law that requires all board members to approve a motion or issue in order for it to be considered passed for North Carolina and South Carolina?
No. So both North Carolina and South Carolina, they don't address electronic communications of board decisions. They do say something that a lot of people catch on to, that informal decisions are outside of a meeting that are made by the board. Usually, I think the default in both North and South Carolina is the unanimous approval. And I'll have to double check with North Carolina. I know South Carolina is unanimous approval. the same thing is usually read into the bylaws or repeated in your bylaws, especially here in South Carolina. That's a pretty common thing to see in the bylaws. If your documents don't say anything about email, it's because they weren't thinking about email when they drafted those bylaws way back when. But it is an informal decision. I mean, when you have a discussion via email and a decision is made by the board, that is a decision. Do you need to have a vote on every decision that is made through email? I think that depends. If this is a formal action by the board, like a communication would be, then yeah, you need to have a board meeting and a vote to approve it, especially if it's not a normal communication like, hey, we're hosting a pool party, which by the way, don't do right now. We're in the middle of a pandemic. I hope that answers the question. What else do we?
So next question, one person in two separate buildings have COVID-19. Do we need to alert the other owners in the other building?
One person in, say that again?
Two separate buildings, so two buildings.
Oh, two buildings.
One
person in each building. Do you need to alert the entire community? So let me make a big distinction with my example at the beginning of the presentation and what we just heard. If you have a resident that has COVID-19, there are circumstances where the association does not need to make an announcement. My example and what inspired this webinar was that an attendant at the pool who was actually hired by the association and responsible for cleaning the pool due to COVID-19 had COVID-19. So you can see how the association is intertwined there. They hired this person to effectively clean up COVID-19, but this person actually had COVID-19. In this example, the question asked, this is a resident in the building, it sounds like, in one building, and a resident in another building. Unless those people were, unless the association hosted a pool party and those people were there, and it was reported to the association that those people had COVID-19, under these circumstances, I wouldn't think the association would need to make the communication. It depends on how these people have exposed the others. If it's just coming in and out of the building, I don't think that is a crisis communication.
So I know you're going to talk about what you should say. So there are a few people asking about what liability do board members have? So that might be discussed in your next section. So why don't we jump on to the next section and then we'll answer a few more questions.
Sure. So once you decide who makes the communication, which we just briefly talked about, whether it's the president, the manager, your communications point person, and it may depend. You also may have a communication policy that spells that out. But once you decide who, the next question is by what means. And I want to talk about that before I get into the what should it say category, if you don't care. So let's talk about social media for a second. My big takeaway from this presentation that I hope all of you remember is that I hate social media. Most attorneys do. So if we're going to talk about social media, the one thing I'm going to tell you is don't do it. It may seem like a good idea as a board to fill that vacuum to make sure that no residents, take it upon themselves to create a Facebook page for your community and run wild with it. It's never a good idea. Communicating via social media should not be a method of communication by the board, ever. Even if there is a Facebook page out there designated for the community or, a next door website for the community, and something is said on one of those platforms that the board needs to respond to, do not respond to it on social media. Please stay away from it. And board members, when you are on the board, you are fiduciaries to your association. You are one of a number of votes, however many board of directors you have. Please do not make statements on social media about what the board has discussed, what the board will do, or what you will do in your capacity as a board member. It is not appropriate. It's not official. You want to keep it as professional as possible. And any communication you make has the potential to expose the board as a whole. So be very careful with social media. And my advice is just stay away from it altogether. How about email? A lot of you have email or e-blast capabilities. Is that a way to make a communication? Absolutely. It's a great way to get a communication out. If your community is on the elderly side, is email the best way to communicate? Not always. Sometimes email in addition to a follow-up letter may be appropriate. Sometimes in a crisis, there will need to be a targeted communication and then maybe a community-wide communication as well. So for example, let's say there was a major hurricane came through and it has passed, but one of the trees on the association's property had a huge broken limb and it's hanging there. And because this hurricane came through and decimated the area, the association and the manager are having a hard time getting the arborist out there to get this limb taken down, or the maintenance people to get this limb taken down. But they're working as fast as they can. It's hanging over a particular owner's property and the sidewalk, maybe. All right. Do we need two communications? One to that owner, hey, this is what we're doing to try to get somebody out there to take care of this limb. We're on it. Please stay away from this limb. It has a potential to fall. We're doing our best to get to it. Is that appropriate? Yeah, it is appropriate. Is it appropriate to then send a community-wide communication that says, hey guys, this limb is hanging over the sidewalk. Please avoid that portion of the sidewalk until we can get this taken care of, and then do your very best to get it taken care of as quickly as possible. And that should be the priority. If you can get out of communication, you can get on the phone and start calling people to get rid of the limb. Okay, I'm going to move on to now, what should it say? And it's very common for the board to be wary of sending out communications in writing. The word defamation gets thrown out a lot, especially when we're making a communication that involves a particular individual or their behavior. Another example that I can think of that is not COVID related is where an association may have one person in the community who just is mad at the association and is maybe making communications on social media or sending out his own communications about what the board is or is not doing. And maybe it doesn't do any good to respond directly to them or to tell them to stop or to get legal counsel involved. But it may be appropriate to send out a community notice and say, hey, we are aware that there have been some accusations made that this, X, Y, and Z has happened and that the board has done this. We wanted to let the community know that X, Y, and Z did not happen and that this is what we are actually doing. Is that appropriate? Yes. Are we defaming that individual that has made these statements? No. That is an appropriate way to do it. Not use names, not use, don't use specific identifying information like he, she said X, Y, and Z on his Facebook on this date. Don't draw more attention to the issue. You're just going to cause, you're just going to swat the bee's nest, really. So let's talk more about defamation, because I know this is a legal term that gets thrown around a lot and people, it's often misunderstood. So I also get a lot of calls that, hey, I'm a board member and I have been defamed by all of these owners posting on Nextdoor or all of these owners posting on Facebook saying that I'm a horrible person and a horrible board member. And I have to tell them nicely that I represent the association as a whole and all of the board of directors and not you. And I know you feel like they have defamed you, but saying that you are a horrible person and that you are a horrible board member is not defamation. And I have to explain this to them and also explain to them that I, as an association attorney, can't represent them on this claim that is their individual claim. So let's talk about defamation real quick. Defamation is the offense of injuring a person's character, fame, or reputation by false and malicious statements. And under the law, you have to prove certain elements to establish that claim of defamation. You have to have, number one, a false statement. So if it is true, it is not defamation. To say that I saw the president out on the boat on Saturday and he was catching all these fish, and he told the community that he didn't have time to deal with that this weekend. Obviously, he had plenty of time. Is that defamation? If it's true, if he really did see the president out on the boat catching fish and the president had said, don't have time to deal with this, that's not defamation. Does it make him look bad? Yes. Is it unflattering? Yes. But it's not false. Same is true for opinions. My example before, you're a horrible person, horrible board member. That's an opinion. That is not, a false statement. So it needs to be really specific. Let me give you a good example that plays well into the claims of defamation or the elements of defamation. President Bob lies all the time, and he's lying about X, Y, and Z. And let's say that statement is posted on Nextdoor. All right. Let's also assume that Bob has never lied in his whole life, and he's not lying about X, Y, and Z. So the next element of defamation that we need to prove is, was there a publication? All right, it's posted on Nextdoor. And if you look on this Nextdoor page, there are 200 some residents in this community, and they're all on there. Would this qualify as a publication under the defamation elements? Probably yes. What if that same statement was made at a dinner party at one of the residents' house in front of 5 of the residents? You know what happens when something is said like that at the dinner party. The rumor spreads. Defamation only applies to the initial utterance of the statement. So you have to go back. Was saying that to 5 people at a dinner party a publication? Probably not. All right. So remember our example. Bob the president lies all the time, and he's lying about X, Y, and Z. Let's assume that it's back on Nextdoor. All right. The publication causes damage to the plaintiff. Here's where defamation usually falls apart for community association matters. You have to have damages, quantifiable damages. If it's money, then it's money. If you've lost your job, then it's job loss. It's due wages. If you've lost clients, businesses, contracts, those things are damages. That's what you're looking for. For a board of director, you all are volunteers on these. Most of you are volunteers on these community association boards. Not being reelected as president because, Bob not getting reelected as president because of this statement, is that a damage? No. He has no financial benefit from being the president of his HOA. Now let's add some facts to this example and say that Bob is actually the owner and manager of a local newspaper. And again, statement is President Bob lies all the time, and he's lying about X, Y, and Z. He's also the HOA president. Let's say the publication, instead of on Nextdoor, was made in an op-ed in the competing local newspaper. All right, now do we have damages? Yeah. He runs a newspaper. His business is getting out the news. And this resident has posted, or has written an op-ed in the competing newspaper and said that he lies. That affects his business. That affects whether or not people are going to be buying his newspaper. He probably lost business, and he probably lost money. That is a perfect case of defamation. Also have, you hear a lot of people throw around slander and libel. So I also want to tell you what those mean, and hopefully you leave here with a clear understanding. Defamation is the umbrella claim. There are 2 types of subcategories of defamation. One is slander, one is libel. Slander is in the spoken form, meaning it's verbal. Somebody says something, and it has to be a publication, not just at a dinner party, maybe a speech. Libel is the written form. It's actionable both civilly and criminally, and that's in North and South Carolina. There are also some examples of when defamation, either slander or libel, is per se defamation, meaning that you don't have to prove the damages part. And there are very specific examples of when that applies. If the statement is that the plaintiff committed a crime, the plaintiff is infected with an offensive or contagious disease, or if the plaintiff is unprofessional or incompetent in their trade or profession. Now let's talk about the second one, infected with an offensive and or contagious disease. COVID is very contagious. So if we make a communication that identifies someone as having COVID-19 and it is not true, and we publish that statement, they don't have to prove that it damaged them. It is per se defamation. So the big takeaway from this presentation is, especially with COVID-19 communications, is you don't want to give any identifying information in those communications, in those announcements. Let's talk about the last example of per se really quickly. The plaintiff is unprofessional or incompetent in their trade or profession. Remember the example I gave earlier, that the president is a horrible board of director. Yes, that is an example of them being incompetent as a director, but it has nothing to do with their trade or profession. Even if they are a retiree and their only job is to sit on this board of directors, they are volunteers. That is not their trade or profession. They are in that role voluntarily. Okay. Any questions about defamation? I know that was a lot of information.
Lots of information. So I'm going to go back to social media for a second.
Yes.
When you refer to social media, Facebook is the one we talked about, but does Nextdoor, Twitter, and the other social media sites all fall into that social media category?
Yes, definitely. All of
How
those.
about newsletters? So newsletters are a form of communication.
Sure. Newsletters, e-blast. I think I put those in a separate category because they're not on this platform controlled by some third-party social media conglomerate like Facebook or Nextdoor. Those are communications that are created by the board or the management company with assistance by the board. So no, I don't. I would consider those options to be a viable way to communicate in a crisis. Putting it in a newsletter. Usually, if it's a crisis, you're not gonna have time to get it in the newsletter, or it needs to go out before the next newsletter. So
in a crisis, we're rushed to get information out. What protections do board members have in communicating types of events?
Yeah, sure. Well, you've got multiple layers of protection as a board of directors. One, the Nonprofit Act, by statute, you have some protections as a board member. Two, pursuant to your governing documents, most all documents alleviate and release the board of directors from some liability. You're not going to be released from gross negligence, right? You're not going to be released if you did something that was just unreasonable. But let me talk about that for a second. As a board of director, you have a fiduciary responsibility to the association to act reasonably. It's a business judgment rule as well. You need to act as a reasonably prudent business person in making these decisions. How do you do that? The best way to do that is to get advice. When you are in a business and you don't know enough about making this decision, what do business people do? They consult, right? They talk to legal counsel, they talk to PR firms, they talk to consultants. So is it a good idea for the board of directors to get advice from legal counsel before they make a crisis communication? Yeah, if you have time, it would be good.
Okay, based on your social media discussion, should a community take down its Facebook page?
Yes, I think so. And are you going to make, the residents, are they going to be unhappy about that? Probably. But as a board, if you can, if the board is the one who sponsored the production of the Facebook, and you have the ability to take it down, I think you should. You should give them some information on how to get in touch with the board, though, and explain why you're doing it. You know, we're taking down the Facebook page. This is not a formal way of communicating, and we want to be sure that all communications are, you know, are official to our, you know, to our membership. If you have a concern or question, no, we don't want you to go to Facebook because it can get lost in translation. We want you to go to the management company and use the procedure we have set out for that.
So our community has combative neighbors that post minutes on social media sites. Can we ask that those be taken down? Because it tends to compromise our relations with vendors, et cetera. So.
Yeah, sure. So board meeting minutes, right? That's what they said? Not member meeting minutes?
Board meeting, yes.
I assume that those residents got a hold of them because they made a records request, and then they decided to share them with multiple people. You know, if there's some sort of information in those board meeting minutes that are inaccurate, there's certainly a way to combat that and challenge that. If the board meeting minutes are accurate or redacted or, you know, the question is, well, let me answer the legal question. Can you do something about it? Absolutely. You can demand that they take it down. Should you do something about it is a whole nother question. Does the board want that kind of PR that, you know, that person is then going to go back to social media and say, hey, I got this nasty letter from the board's attorney that's telling me to take down these board meeting minutes. Obviously, they're hiding something. Your board meeting minutes should be something that you shouldn't be scared to share, is my takeaway.
So if a community is communicating by email and some residents don't have email addresses or access to email, are we at risk by not communicating with the entire community?
I wouldn't say at risk unless we're talking about communicating notices of meetings. So your governing documents in the Nonprofit Act have requirements for mailing, in most cases, notices of meetings of the membership or notices of you know, proposed amendments or actions that need to be voted on by the membership. With few exceptions, your documents may allow you to do written ballots or other things. So no, I don't, you know, sending out e-blasts to the community where a certain percentage of the community doesn't have email, I wouldn't say you're at risk, but my recommendation still would be, you know, you're not getting your message to the full population, right? If you to your membership to know something, and it's very important that they know it, sending it via email and then following up with a letter is an option for those communities that don't have emails.
So next question, we had a dog jump a fence and attack a neighbor. The animal control, they handled it, but we caught grief as the association because we did not tell everyone whose dog it was. Should the association share that information?
No, I don't think so. I think what would be appropriate in that situation is for the community to make a statement that we are aware. We have received notice that several of you want to know, you know, what house this dog came from or what person this dog belongs to. You know, this is what was reported to us. This dog got out and attacked the neighbor's dog or the neighbor. If you need additional information, you know, you should, or if you have any complaints or concerns regarding any dogs in the community, you should notify the manager. Keep it simple, kind of redirect the issue is how I would handle that. And then maybe even consider not making communication at all.
So within defamation and communicating, I guess, in a crisis, how can that, or if it affects resale values in a community, is that considered damages?
So I think the question is kind of asking, can the association sue for defamation. So let's say the false statement is about the board of directors or the association as a whole being a horrible community to live in. It's a publication made in the paper, maybe, and the publication causes damage to that association because now no one wants to buy houses in that association. Sounds like a great case to me.
So in a high rise with common area lobbies, elevators, mailrooms, what are the pros and cons and obligations of communicating when a resident with COVID becomes known, particularly given the disease infection is a potential defamation issue?
So repeat that beginning part, Ben.
So in a high rise with common areas, lobbies, elevators, mailrooms, so and you know that someone is infected, what are the risks?
I think that the risk is giving any identifying information to your community and exposing the association, your management company, the board, to defamation claims, especially per se defamation claims that we just talked about, because this is a contagious disease. So again, you can still make a communication that, hey, community, we have become aware as a board that we have COVID positive, that residents within our community have tested positive for COVID. Please be careful. Please use appropriate sanitation stations. Please social distance when possible. Please wear your mask and, get tested if you feel as though you have been exposed. And please self-quarantine if you have a confirmed case of COVID-19. That is perfectly appropriate. It lets people know that there are cases in my building and I need to be careful. That's the information that needs to get out.
So during a crisis, what can a board do if there is one board member who is trying to subvert decisions of the board by sharing information with other homeowners to create friction on social media?
Mm-hmm. Happens all the time, doesn't it? Well, the first thing you need to consider is whether the association needs to consult with legal counsel and get a cease and desist order on this particular board member to prevent them from sharing confidential information this way. Another option for the board to consider is, do we need to remove this person? If they're not going to comply with our request to stop sharing, do we need to remove it? Another question I think to ask is, depending on what kind of information is being shared on social media, does the board need to make a communication in response that, hey, we know this information was shared. This was not an official communication by the board. It was not authorized by the board. Here's what we're really doing and what's really going on. I think that would be an appropriate way to combat that.
So if a resident has started a Facebook page or other social media websites, can the board request that site be removed?
So the question was if a resident creates the website?
Yes.
Probably not. Freedom of speech. We can't ask people to not create it, but we can officially make a statement that it is not a means of formal communication to and or from the board. And again, social media is a good gauge for your board. So shutting down social media hosted by, on Nextdoor, for example, there's one for every community just about, or shutting down a Facebook group created by the resident probably isn't a good idea. You really want to be able to see what people are saying. It is okay for the board to monitor those social media sites. It gives you an idea of how your community is really feeling about something. Monitor it, and then don't respond there. Take it back to the board and say, okay, how do we want to respond to this and by what means? Not on social media, but do we send out an e-blast to say, hey, it's come to our attention that some of you are concerned about this. Here's what we're doing. I tend to recommend for you to stay away from saying things like, the board saw on Nextdoor that people are saying X, Y, and Z. Just say, it has come to our attention that, this is a concern. and here's what we're going to do.
Okay. I'll ask one more question, and I know you have a few other topics to talk about, and so we'll jump back into that. And then there are a few meeting questions that I will ask. But so this one, are we allowed to share this information or this presentation with the homeowners as justification for us to remove our Facebook page?
Sure. I haven't said anything that is going to make homeowners mad. No, I'm just.
I will say this is public on the CAMS NGT website, so if you wanted to share the link, you certainly can. So, but Morgan, I'll let you get through your remaining bullets, and I'll jump back on in a minute.
Well, hey, I meant to do a polling question earlier, but while we're talking about social media, let me throw up. All right, here we go. Do you, as a board member, use social media for communications? You guys know what I hope the answer is, but be honest.
So far, so good.
Looks great. All right, so for you 10 or so people out there that have said yes, we're not going to pick on you. I hope that what your takeaway from this presentation is not to do it. The problem with communicating via social media, even if you have board approval and the message, is consistent with the board decision, is that it allows people to respond and comment and then share and manipulate what you have said. It needs to be very thorough and thought through, and usually when you're posting on social media, it's just not. Back to, let's see, move that polling. Back to asking residents to remove social media posts. If there is truly something on the social media, on the next door out there that actually does cause harm. Let's say it's about the association. This association is a horrible place to live. I hope any prospective residents that are considering living here don't move in. Is that enough to be defamation? Well, I think that's probably an opinion, so we're going to need a little bit more. But what if the post said all the board members lie, they fine you if they don't like you, if you have brown dogs, you automatically get a $50 fine. All right, that's false, obviously. And it's a publication that's on Nextdoor, and it's about the association's business and how they conduct themselves. And sure, if we can actually prove that several owners lost their contract, lost a contract for sale, or that there is actually a decline in the value of the homes, and it was because of that statement on Nextdoor, do we have a defamation claim? Absolutely. It's just really hard to connect those damages and prove those damages were actually caused by that statement a lot of times. Any questions about defamation, slander, libel per se? I know there were a couple. I'll move on if not.
And I think we've answered most of the questions that have come in on defamation, so we'll let you.
Good. All right, this is the last thing, and I'm gonna kind of leave with this. I think there are 3 big questions to consider in a crisis communication. What is the association's obligation to the membership is the first thing you should ask. So, in the COVID-19 example, what is the association's obligation? The association is not responsible for making sure that everybody stays COVID free. That's you guys are not healthcare providers. You are not ensuring people's safety against this COVID-19. But if your obligation is to keep the pool area clean, and the pool attendant is the one who now has COVID-19, what is the association's obligation to the membership? Well, probably to let them know, to close the pool, to make sure the pool is now clean, to make sure that attendant isn't working anymore after they've tested positive for COVID-19. So, let's take another example that's not COVID related. Let's think about, I always go back to the tree falling over example, but in a hurricane, if there is a tree falling over and the tree was on a community association property, what is the association's obligation to the memberships to take care of that tree? Do we need to get out of communication if the tree is not going to be removed right away? Probably. The next question you're asking yourself in this situation is, what is the association's exposure? What's going to happen if we don't give this communication? Or what's going to happen if we don't mitigate this problem? For the COVID-19 example, if the association knows that that pool attendant had COVID-19 and doesn't say something about it, and then someone finds out that the association knew about it and posted all over Nextdoor, look, the association knew about this, they didn't tell anybody, now the community is completely riddled with COVID-19, they had the opportunity to shut down the pool and clean it, and they didn't do anything about it. Making a communication ahead of time, telling people what you did and didn't do and what you're going to do, and giving them the necessary information to make decisions, minimizes the association's exposure to liability. And yeah, the big takeaway from webinar, that's the goal. Communicating in a crisis, the whole purpose of communicating in a crisis is to protect the association. Yes, that goes hand in hand with protecting and providing safety to your residents, but your residents are the association. They're all shareholders. Their money funds the association. When the association gets sued, the shareholders are sued, the owners are sued. So the goal of the board is to minimize the association's exposure. Number 3, how can the association minimize liability and or prevent damages to assets? This doesn't always come up, but it's a nice baseline question. If there is some sort of monetary or quantifiable damage to the association that needs to be mitigated, you need to do that in the communication. I think, the tree example is a perfect example. We're preventing damages to assets as well. That tree is an asset of the community because it's community property. It's on the sidewalk, or it's laying across the playground equipment, or, it knocked the roof off of the community gazebo. We want to minimize the liability, the damages as quickly as possible. We want to let the association know what we're doing to minimize that liability and to prevent further damage. So again, just 3 questions that should pop into your head as soon as a crisis occurs, whether it be, a weather event, COVID-19, or some other, incident. What is the association's obligation? What is the association's exposure here? And how can we minimize the liability or prevent damages to the association's assets? Finally, do we have any questions about those questions? Or any questions about communicating in a crisis that's not related to weather events or COVID-19?
That's most of the current questions. A few more may pop in, but go to your final topic and I'll have a few more and then we'll wrap up.
Okay. The last big takeaway here today is don't create a crisis. So Ben gave me a great example today before the webinar. A social media post was made by a community that said, hey guys, we're going to start enforcing sign restrictions. I know we haven't done it for 20 years, but now we're going to enforce them. So make sure you remove all the signs in your yards. Well, we're living in a very political environment right now, so the signs in those yards are political signs. They are probably graduate signs. They are also probably Black Lives Matter signs, Trump flags, Biden signs, Biden flags. It always happens in an election year that associations decide all of a sudden to start enforcing sign restrictions. Of course, the response to that social media post was a huge backlash from the community saying, hey, you're targeting Black Lives Matter movement, or you're targeting the, Trump supporters, or you're targeting the Biden supporters here. Again, the number one thing that they did wrong was make this communication via Facebook. It gives people the ability to then respond, and then that comment just snowballs because everybody sees that comment and thinks, oh yeah, they're right, they are targeting us, I'm going to comment. And then somebody else comments. And you can see how the anger and the crisis level just will rise. So, don't create a crisis. The first way you can avoid creating a crisis is not using Facebook, not using social media. Another way not to communicate a crisis or not to create a crisis is probably to get some legal advice when it's going to be a hot button topic like sign enforcement. The same thing happens with flags often, the signs as well. But any kind of restriction that you haven't been enforcing, that you are suddenly enforcing, posting that on social media or even putting it in an e-blast is not a good idea. This is a very formal decision by the board. You either reserve it for an annual meeting. Hey, we're going to start enforcing for X date. Or, let's say it's an amendment. All the membership voted on it. Everybody knows that this is a change, and you make an announcement formally, e-blast letter, newsletter, that, hey, by the way, guys, we got this recorded. It is official. Now you are not going to be able to, park your bicycle on the sidewalk anymore, and we're going to fine you if you do it. Making sure that communication comes across very professionally and doesn't create more headaches for the association is always the goal.
Okay, a couple final questions. We're about out of time with 3 or 4 minutes remaining. So alligators in ponds.
Ooh.
What should our responsibility be? And some owners think we should remove every time one appears.
That's a great question. Kiowa comes to mind. I don't know if anybody saw, I think it made national news, the lady that was attacked and killed by the alligator on Kiowa Island. Crazy story. I think, again, most of the time it's just going to depend on what the situation is. For example, Kiowa Island right now, probably if there are any other alligators in that pond, it's probably in their best interest to get those removed. But let's say you've got, you've had alligators in your pond for a long time. You've never had any incidents of alligators attacking people or pets or causing any problems. Do you need to, communicate to the community that there is an alligator there, or that, or do you need to remove it altogether? And let's not even talk about the actual communication. Do you need to get rid of it? Probably not. If it's been there forever, it's not hurting anybody, and it's not caused a problem, no. Should you have signs up at those ponds that there are alligators? Yes. It is a dangerous condition to have a known alligator in your ponds on community association property. So if it is a new alligator that hasn't been there before, that it just has wandered up, should you let the association know that, hey guys, by the way, we got a new resident alligator here. Let us know if there are any issues. We'll post signs. Here's what we're going to do. We're going to make sure, that we keep everybody safe.
Okay, back to social media. Can you post rules or processes that are asked by residents on this platform? So example, fireworks allowed in a community.
So on social media, no, big no. I understand that, it's just a rule. You're not making a communication and it shouldn't cause a crisis. But one, in reality, any kind of communication where you're adopting a new rule or explaining a rule needs to be an official communication by the board, especially if you're adopting one, right? If you're adopting one, usually it's going to require some sort of resolution. And in South Carolina, it's going to require you to record it. The HOA Act now mandates that you have to record all rules and regulations of the association. Let's say you've done that, you adopted it, there's a resolution, and you've recorded it, and you want to let your community know that, hey, it's now in effect. I still don't want you to do it via social media for a number of reasons, because it always goes south. But can you do that via e-blast and say, hey guys, by the way, it's recorded, and next week we're going to start enforcing, so don't do it? Yes, you can and you should.
So we have, that's our last question on social media and defamation.
Okay.
We have one question around meetings. And so just a reminder that we do have a whole webinar on meetings and how to conduct a meeting in a COVID situation. But one question regarding meetings, if you would, meeting in a parking lot. Are we allowed to hold our meetings outdoors in parking lots to circumvent some of the space and distancing requirements?
Meeting of the membership, or did they say?
Meeting of the membership.
Meeting of the membership? Sure, why not? I think you can have it anywhere that makes sense, right? If you're holding it out in a parking lot and it's 103 degrees at noon on a Saturday, it's probably not a good idea, right? People are going to have a heat stroke. But if it's in the evening time, it's well lit, people can hear you, it's safe to hold the meeting there, I see no issue with that. Put it on the notice where it is and what you're going to do. I like that.
Okay. Well, I think that is all the questions for today. Morgan, I thank you for joining us today. I have one maybe disclaimer. All this advice today is general. If there are specific issues that need addressing, either contact Morgan or your existing association attorney, just for a more direct answer. So don't just keep everybody safe. Morgan, would you add anything else on that?
This is such a heavily fact-dependent issue, communicating in a crisis. Really anything that's going on with COVID is just so fact-dependent. We don't have enough case law or examples, or we just don't know what's going to happen. So yeah, it's always a good idea to reach out for specific issues and make sure that somebody has given you some good sound advice. Thanks for that, Ben.
So thank you. Well, as a reminder, this webinar will be posted online at camsmgt.com, the board member section. It will probably be posted next week, early next week, so give us a few days to get it live. Morgan, I'll let you sign off, but we do have one last poll we're going to send out, and just a little bit of feedback on the webinar, so please fill that out, and we do thank you for attending today.
Thanks, guys. Appreciate the opportunity.